I had to stand up for my rights.
Hey everybody, I hope you're doing well and that everyone had a safe 4th of July. Hopefully you got to enjoy at least some fireworks and something delightful. Today we're going to be hopping straight into Mapp v. Ohio, which is the next case in the exclusionary rule discussion that we've been having with the previous cases like Olmsted and Weeks. In this particular instance, this is the case that gets you the incorporation doctrine that we've talked about before, applying the federal constitution to the states themselves, here in the application of the exclusionary rule and the Fourth Amendment. On May 23rd of 1957, 3 Cleveland police officers came to the house of a woman named Dolly Mapp.
Most of my friends called me Dolly. Very few called me Dolly.
On information that there was someone in that home that they wanted to talk to related to a bombing that had occurred. Now, this individual's name was Virgil Ogletree, which is quite the name. The police were also interested in some information they had received about illegal gambling and betting slips. Now, Dolly had gotten herself involved over the years in some illegal gambling and racketeering activities with a local Ohio mobster named Shondor Burns. Now, the facts of this particular interaction are kind of interesting. So Mapp lived on the top floor with her daughter of this particular house. The police officers came to her home, pounded on the door, and demanded entry. Rather than opening the door and letting them in, she called her lawyer, and the lawyer said, "Don't do it." So Mapp said, "You're not coming in without a warrant." At the time, there really wasn't much the officers could do. They didn't have a warrant on them, so they left. One stayed behind to watch the building, and the others called headquarters to see what they should do next. A few hours later, more police officers showed up. They then went back to her home, pounded on the door, and she didn't answer right away. And so, deciding to be impatient, the police forced entry into her home, found Mapp, and detained her. As this was all going on, Mapp's attorney actually showed up at the scene, and the police officers refused to allow him into the area or to speak with his client. While the police were dealing with his lawyer on the outside, on the inside, the cops were shoving a piece of paper in Mapp's face, which they purported to be the warrant that justified them entry into the home and to search things. Well, she decided at the time to grab said piece of paper and, as the case put it, shove it in her bosom, because that's always the first place I put anything. The police, of course, wanted it back, and a struggle ensued. As a result, she was handcuffed, the police took back the paper from said bosom, and she was arrested for being belligerent in the interaction. She started crying, saying they were hurting her, and as they basically picked her up, they then took her off to her bedroom rather than out of the home, and the police officers then spread out through her home and started searching everything. Drawers, chests, if you can think of it, they dug into it. During the search, the police found certain items. These things included betting slips and other paraphernalia related to illegal betting, and they also found porn. They hauled her off to jail, and she stood trial for the possession of the betting paraphernalia, which was illegal in Ohio, but she was acquitted of those particular charges. Then the police decided to get a little bit shadier than they already had been, and when she later refused to testify against Burns, they then charged her with the possession of pornographic materials. At that trial, the prosecution wasn't able to produce the warrant. They weren't able to produce any evidence that it ever existed, and no one could exactly explain where it went. There was no cause given as to why no one could produce this particular piece of paper. But despite that and everything else, she was convicted of possessing pornography.
She was sentenced to the maximum, which was 7 years, plus a $2,000 fine.
7 years for what? That case wasn't right.
And this is where I actually get kind of annoyed. This case ended up at the Ohio Supreme Court, And the Ohio Supreme Court said that there was a reasonable argument that the conviction should be reversed because of the methods used by the police to obtain the evidence. As in, the Ohio Supreme Court said, y'all jacked this up super bad. But because they did not take the evidence from her using brutal or offensive physical force, they decided that the exclusionary rule should not apply, and the conviction was upheld. Mapp then appealed to the Supreme Court of the United States using the 14th Amendment argument. At the Supreme Court, the justices looked back at the cases that we've already been talking about, particularly Weeks and Olmstead, where they were trying to figure out where the bounds of the Fourth Amendment applied and how the 14th Amendment applied to that. The court here took great pains to remind everyone about the language in Weeks, where that particular court had decided that using illegally seized evidence against a defendant at trial basically made a protection against illegal search and seizure that we have in the Fourth Amendment useless. What good does it do anyone to write it down on paper if the courts won't actually enforce it? And as a result of that line of thought, from Weeks forward, the federal courts and the federal police were no longer able to use illegally gotten evidence at trial against defendants. They were excluded, hence the name of the rule. The court then turned to a case called Wolf v. Colorado, which was a case that actually said that the 14th Amendment applied the Fourth Amendment to the states. So Wolf got us incorporation of search and seizure in the Fourth Amendment to state courts. But the Wolf court decided not to apply the exclusionary rule to illegally gotten evidence in that particular case. And the court in this instance, in Mapp, basically said that the reason they did so was an incredibly fact-specific one, grounded largely in the fact that the Wolf court said the states are taking steps to moderate this behavior on their own. There are other remedies available. We don't need to get involved. And the Mapp court, the one that we're dealing with here, basically said, yeah, that's not binding on us and it's not good enough, so sorry, not sorry. In fact, they took quite the opposite position and said that all evidence, all of it, obtained by search and seizure in violation of the Fourth Amendment of the Constitution is inadmissible in state courts under the exclusionary rule. Since the Wolf court went to the trouble of saying that the 14th Amendment incorporated your Fourth Amendment protections in state court, with that also comes the exclusionary rule. They travel together. The court also made a series of policy arguments, one of which they said was just common sense. It makes little sense that you should have a prosecutor on one corner in a federal court that's incapable of using certain evidence to prosecute a defendant, but the state prosecutor 5 feet away on the other corner could take the same evidence and use it against a defendant in state court. You end up creating a situation there where your one right, the singular Fourth Amendment protection, doesn't get applied equally depending on which sovereign happens to be prosecuting you. In one instance, you get a protection, and in the other, it's abandoned. And that's just, it makes no sense. And with that came the fact that some federal officials were being a little loose with their jurisdictions and how they decided to charge things. And so you would see a federal police officer of some sort skip the federal courts when they arrested somebody, and they'd go to their friend at the state prosecutor, give them the evidence, and have the defendant charged in state court, allowing the federal officer to use evidence he had gotten illegally to prosecute the defendant. And the courts were pretty clear that because the Fourth was enforceable on the states through the 14th, they didn't want to give police officers the ability to simply waive your rights for you by suspending your enjoyment through their choice of which prosecutor to go to. And the court quite readily admitted that a concern from Judge Cardozo, who we've talked about before, that the exclusionary rule provided an out for defendants. It set guilty people free. This court said yes, it probably would. That is probably something that will happen. And in doing so, what they ended up saying is that it's the law itself that sets the defendant free. Nothing can destroy a country faster than a failure of the law to enforce itself, and a judiciary that, because it fails to enforce its own laws, loses all integrity with the people. Citizens that do not respect the law don't follow the law. And once that happens, everything just kind of goes to hell in a handbasket. And with that particular consideration in mind, this court was willing to say we would rather have guilty people go free than have the rights of the individual citizens trod upon and the integrity of the courts questioned because we failed to do what's right. And so in 1961, we finally get incorporation of search and seizure in the Fourth Amendment to the states and the exclusionary rule to go with it, preventing state police officers and other enforcement agents from illegally collecting evidence and then having it used against you in court. So let me know what you think about the particular rationale down below. I tend to agree with this court. You can't have a right without the remedy to go with it. They do tend to travel with one another, but let me know what you think. And until we're together again, I hope everyone is well.